Let's answer some legal questions.
Okay.
First question we have today is wrongful termination. I just want to be clear, in Texas, wrongful termination is not a thing.
No.
We have what's called an employment at will state. Now, Austin, you work for me. I love you. But if one day I decide I don't like you anymore, I just don't want you to work for me, I can say, Austin, you're terminated. It's employment at will.
Nope.
You're
You do that, and I will submit a potential new client request saying I was wrongfully terminated from the Silverman Law Firm for a free
we
consult.
we may have a conflict on that one. You do have things in Texas and across the country. You have a violation of a statute or an illegal termination.
Sure.
For example, you can't terminate someone because of their race, their religion, age, disability.
Yeah.
Those things are clearly codified violations that are protected. And that is a type of, I won't call it a wrongful termination. I would just call it a violation of the statute.
Yeah.
Now, there is an exception where you can, in a sense, be wrongfully terminated, but it's very rare.
Yeah.
If you have an employment contract and it's a term contract for a year or 2 years, promises you some sum of money, and maybe in that contract says you can only be fired for cause, and your employer then terminates you, that is a wrongful termination, but really it's just a breach of contract.
Yeah.
So there is that, but that doesn't happen very often. So we get a lot of calls on wrongful termination, and just want to be clear, not a thing in Texas. Maybe you were fired for violating a statute.
So people will come to us and they have a judgment against them, but they have absolutely nothing. They ask us what they can do. And so those are two sides of the coin there, right? And Texas is, for better or for worse, is quite judgment friendly, right? If you have a judgment against you, Texas is a good place to be. There are a lot of homestead protections, a lot of things that make for exempt property, including personal property, up to a certain amount of money. Yeah.
We get a bunch of broke people calling us,
Yes. Let's not call them broke. Let's just
financially challenged people
okay.
that don't have two nickels to rub together. And they've already got a judgment and they're calling us and they're like, what do we do? Good news. The state of Texas was founded by debtors and criminals. So we have some of the most debtor friendly laws in the entire country. In Texas, you can have as big of home as homestead property as you possibly can afford. You could have your floors and your counters made out of solid gold and millions of dollars of homestead improvement, and we will never let creditors get to that. So you can have all this stuff that the creditors are never going to get, and your creditor's just going to be out of luck.
Mm.
So what do we tell those people when they call in? Usually, if the person doesn't have anything and he's never going to have anything, we just tell them you may not want to do anything. If they've been sued, we will say, maybe let's put up a little bit of a fight. Let's not make it super easy. There's no one day you may hit the lottery or may start a great business or you may get back on your feet. So let's not just give them a judgment. Let's put up a little bit of fight.
Sure.
But sometimes you've got some people that are in their 70s and they don't have anything.
It's throwing good money after bad. It's just not worth it.
Yeah, exactly. Now there are some limited ways in Texas. One of the few ways that you can collect, primarily the debtor has to have real estate that's not your homestead property, like
Mm.
investment property. That's a good way to, you can sell that, get money for it. Or the debtor has to have some money sitting in a bank account.
Yes.
Okay, tell me about this influencer that struck a pose.
Yeah. An influencer was sent a cease and desist letter to delete all of their social media accounts because her poses were allegedly violating copyright that other influencers were doing things with too.
Are we talking about like
Okay.
Zoolander poses,
So I
the
actually can tell
blue?
you. They're very generic. The
Okay.
poses that this person was doing were
Right.
exactly the same as every female influencer does on Instagram. They were all the same sort of poses. There was nothing special about this.
Can you demonstrate one of the poses for me?
I really can't. I would need a much more low cut shirt to do that.
you're not correctly endowed
I'm not
to
correct down to do those
to
poses.
just
Yes,
so we're not talking about Blue Steel or Magnum
we are
cigarette.
not.
But so is a pose copyrightable?
No, you cannot.
Mm.
It's not unique enough. Other people can do the pose. You can't copyright a pose someone's doing with their body. It's not something you can do. I guess it does get a little bit interesting, right? Because you can copyright dances, right? You can copyright dances.
So we think on the weekly docket, our official opinion is a pose in itself is not so original as to rise to the level of copyrighted material. Moving right along, 18-year-old daughter out of control.
Yeah.
And the guy calls in and he says, my daughter's so out of control. I want you to get me an adult guardianship for her.
Yeah. She's not calling him back. She's smoking marijuana, all that. And I need a guardianship. Let's back up a little bit and just explain. Some of our listeners may know, but let's back up and let's explain like what guardianship does. If you are granted, there's a guardianship over you. If there's a guardian over you and you are a ward, okay, the court appoints that sort of a situation. You are legally dead as a ward of a guardian. You cannot do anything for yourself for the most part. You cannot sign anything, any contract you sign is usually going to be completely void. You can't enter into contracts, you can't get married without your guardians, all that sort of stuff. And it basically takes away the normal rights that you would have as an adult of the United States. So we try to take guardianship as the absolute last measure and always go for least restrictive measures if there is something legitimate to accomplish here. But in this situation, where they just don't like that their daughter is not calling them back and is smoking marijuana, guardianship is not appropriate here. The 18-year-old daughter is an adult and she can make her decisions, even if they are bad ones.
Guardianship is mostly for old people with dementia that have lost capacity, not for out of control 18-year-olds. But I empathize with this gentleman because I
Sure.
have teenagers and it would be nice if I could have some type of they turn 18 and I need to rein them back in.
Sure.
So for better or worse, the guardianship process is not available.
If they're a minor and they have some mental issues or something of the sort that makes them unable to care for themselves and unable to take care of themselves, and they turn 18, so they become legally an adult, and a
Mhm.
parent wants to see guardianship for them in that situation, that's absolutely valid and it usually can be accomplished there. But many times I'll have people I talk to who, when I explain to them what guardianship is and the situations where you can have guardianship, they're like, "Oh yeah, no, I think she or he does have mental issues." I'm like, "Okay, look, you're only saying that now that I tell you what guardianship is for. So I'm sorry, you can't fit the square peg into the round hole here."
Yeah, that's an excellent point, but not just because they're a wild child.